just because the parent has a disability is not enough. So again, it has very, very good language, but be careful on how you apply these cases based on the facts of your particular case. So use 352. All right, thank you, Ms. Danielle. Thank you.
Who are you?
Danielle Babb.
Introduce yourself.
What law firm? Danielle Babb. And I do the writs for our office as well. So mine is the FR timelines. We've had a lot of cases and trainings about this over the last couple of years. And we're going over it again because we're still getting it wrong when we are trying to make our arguments. So it seems a bit unfair to have two parents who come in as a family unit, and the child is left with one parent and the other parent is sort of kicked out in the cold and they're not entitled to FR. So everybody is kind of like, my client deserves to have FR services, and we've been really pumping this family enhancement services. But you really have to go back to, and all of the cases that are cited under family reunification, the timelines, they all have one thing in common, and they lay out what the goal of dependency court is. In all of the cases, you'll find where it says that the goal of dependency court is to reunify the child or children with at least one parent or with a parent. It's throughout 361.5, 16507, and 300.2, where it sort of lays out the goals of dependency. So as long as a kid is with a parent, the goal of dependency has been met. And the court does not specifically have to reunify the child with the other parent, because there's no reunification needed because the child is already with the parent. So we'll go through a couple of the cases and sort of look at it. And in Ray AC, the court basically said 361.5 doesn't apply. So it doesn't make sense to sort of argue these topics of why your client should get FR in this instance, because the court has said 361.5 doesn't apply, therefore family reunification services, it's not applicable. Okay. Again, this court said that the timelines do not begin to run until the child is removed from both parents and in out-of-home placement. Just going to the non-custodial parent, who the kid didn't live with before, not considered out-of-home placement because the child is with a parent. Okay. The next case is the Calvin P. case. In this case, it's sort of like what Rebecca was talking about. It actually was initially a U10 and 11. The mother wasn't given reunification services, but the court sent it back saying, no, you didn't evaluate it under 361.5C in terms of whether or not it was going to be in these children's best interest, because at the initial part of the case, the kids were in out-of-home care. They were placed in foster care. So when it came back, the trial court said it will be in the kid's best interest for this mom to get FR services. So the court ordered FR services for the mother. The kids went back to the father like shortly thereafter, a couple of months after. So when they came back for the 6-month review, the trial court said, well, you didn't get FR services, but oh well, too bad, so sad. It kind of just was encompassing the father getting family maintenance services. But the Court of Appeals said no. Once the trial court orders FR services, the department has to offer it. So I know many of you have indicated, well, my court ordered family reunification services. Well, then you might want to use the Calvin P. case and say at the 6-month date, well, Your Honor, I understand what they're saying, that my client wasn't entitled to it. However, 6 months ago, at the disposition date, you ordered FR services. Because outside of that, again, you go back to the AC case, they're really not entitled to the FR service. So that would be the only way to hang your hat on actual reasonable services and whether or not the department has complied, because what the Court of Appeals said in that case to the department is, we understand that they may not have needed to have it, but you disregarded a court order, and that you cannot do. Okay. One of the other things was they found that in this particular case, with this family, these specific facts, it was in these children's best interest to have reunification services with their mother. So the fact that the court ordered it, and the fact that these children were gonna benefit from it, the Court of Appeals said that the services should have been reasonable, and they ordered an additional 6 months. Moving along to N. Ray A.L., this is a 4th District Orange County case. This is where this family enhancement services business first derived. It started with the trial court. It was the trial court who, I guess in trying to split the baby, appease the parties, whatever, indicated the father won't get reunification services, but he'll get family enhancement services. And the Court of Appeal just sort of piggybacked on it, like, that sounds like a good idea. We'll keep that, we'll keep enhancement services, because it didn't really mean anything in particular, so they didn't sort of say no, enhancement services don't mean anything. The court in that case, just double check, indicated that one of the reasons why they didn't need to do anything about the services not being reasonable is, again, there was no need to reunify this family. So they didn't have to do an analysis or evaluate whether or not reasonable services had been provided, because that would be family reunification services under 361.5, and you didn't get to that in this case. So the court did evaluate that. The next case, Pedro Z, that was out of LA. Referee Skiba had that case. She, at that point, sort of piggybacked on that AL case, and in order that they were to help the father to do something sort of like enhancement services, mainly because in the Pedro Z case, again, the child was living with both parents at the time the department got involved. So it was another sort of attempt to say, well, this is a family that's going to, wants to get back together, and gave the father some services. One of the things that the court distinguished was, the reason why you have to distinguish between 361.5 when they're offering reunification services and when the child is placed with a parent is, they said the loss is not the same. The loss to the parent is not the same. They may feel like it is, but it's actually not. In the instance where they are losing, the previously custodial parent is losing custody to either a previously non-custodial parent versus a custodial parent losing custody to alternative placement, i.e. foster care. 2 totally different losses, and that's why they equate it differently. So it said if the minor remains in the custody of one parent, 361.5 plays no role. One of the other things that the case indicated is that the argument you may want to make is that solid best interest argument. Making an argument to the court about the child's bond with the other parent, and why in this particular case offering SBAR services or keeping the case open, not JTing with the flow, is actually in the child's best interest, because the parents plan to reunite, and obviously an argument would be it's better to be under the court supervision if the family wants to reunite than for the court to close the case and the father or mother will be back in the home the next day and cause more problems. And sometimes the courts have been buying that argument about intact family. But pretty much besides it being in the best interest of the child, it's going to be hard for the argument to stick that that parent is entitled to FR services. In fact, the other thing that Pedro Z pointed out was in WIC 16507B, it indicates that FR services shall only be provided when out-of-home care or, is needed. So it's one of the things that typically the court doesn't point it out, but it's just to kind of show you one of the things these cases, the cases do as well is make a distinction between 361.2 cases where the child's gone to a previously non-custodial parent, and that previously custodial parent wants FR, that's where Pedro Z is making that distinction, where it's not the same type of loss, but you never get to those timeline running. So there's one instance, and it is in the, I think it's in the Calvin P case, where it's explained out. We've had trainings on this, and I know it's a place where it's a little confusing, but the one instance where there's both FR and family maintenance is when you have a 361.2 B3 situation. And it's laid out very well in the Calvin P case, but it's important to distinguish because it's sort of a fallacy to have the 361, a 364 set and then a 290 set as well. Yes.
Did the timelines run for the Calvin P FR parent?
Yes, it did.
Even though there was not a dispositional removal from the other?
Well, what happened was the kids went to the father a little bit later.
So the timeline started when disposition.
They start when the kid is removed from both parents. So like if you have the initial detention, oh, I'm sorry. when the kid's not in the home at detention, the home of either parent, that's not the removal. The removal is at the disposition date. That's when the timeline starts. So even though technically, like let's say, the 18-month date is 18 months from the beginning of the case, but in terms of the timeline actually running, it starts when the case is at disposition. Yes?
Guys, correct me, what is the case that came down 3 weeks ago that really challenged the idea of the statutory right of reunification under 361?
.2?
Yeah. What was that? And what do we do with it?
I
Because
think
it
that
says
case
you don't
needs
have a
its
right to
own
training.
training. I don't know if we have enough time to wrap.
Do you suggest that the attorneys still go forward? I mean, because what happens if they're going to say, Your Honor, you have discretion, this was a non-custodial parent, the child's going to stay, there's no FLO, this child has a significant relationship with my client, the mother, I think you can order FR, and
But
county counsel starts waiving that case.
I would make my argument still on 361.2. I don't have the case in front of me, so I can't go over all the facts with you right now, but I would still try to make my,
And
go ahead.
argue best interest,
Yeah.
really. I think
Because
that's the best shot.
361.2, it allows the court to do that, to do both.
Yeah, I know. We had this discussion because, the statute says
Right.
reasonable services, and yet the case, the published opinion said there isn't.
I would still be arguing 361.2 until we have something different from the legislature. And what you have to do, one of the reasons that we're talking about this training and talking about these old cases is what we were seeing sometimes from the record, or what we're seeing from the cases that are coming down, both published and non-published cases, or some directives sort of from the court, and looking at the issues that CAP is sort of attacking. They're looking at this 361.2 issue a lot. There was like 4 cases last year in 2013 on 361.2, and you have another 3 cases so far this year on 361.2. So it's sort of and that's just the published cases. That's not the unpublished cases. So that's the Court of Appeal and CAP saying, look at this issue, it's not being dealt with, correctly, and they're not publishing the cases because they haven't done it already. It's just kind of like more issues and more ways to look at it. And I think 361.2 has a lot of little sort of nuances depending on what your fact situation is. And I think that's why we have so many of those cases coming out. So that's why I would still make that argument on my position, because I think that's just sort of one case that's laying it out that way. And I think you could collectively look at some of the other 361.2 cases and distinguish that case. Yes, Dennis.
When it's not
Why am I the only person who
when it's not a 361.2 case, it's 2 previously custodial parents, one gets the kid and one doesn't. Can the court give the parent that doesn't get custody, give that parent FR?
So that's like, you
Calvin
know,
P,
Pedro Z, they were both custodial.
right?
And I think that's where you make that argument.
But is
when you
Calvin
ask
P
me-
authority?
Yeah, it's a published case.
So it's authority
But,
for that.
but no, because it's very fact specific.
Right.
The Calvin P case is very fact specific, and I was only pointing it out to the tune of a lot of people saying, hey, my court is ordering FR service for that parent. And then we get to the 6-month date, and then there's nothing that I could do. I don't know if that's gonna work, but that's a case you could try to make your facts analogous to by saying it's in the kid's best interest. I don't know if that Calvin P case is gonna stand for what you're pointing out.
But there's nothing that says the court can't give FR.
No, and I think it's what you, well, the law says no, because it says once the child is with a parent. I'm saying, and then you use the cases to sort of distinguish or make your best interest argument. But I do think that the law says, no, you don't get it, because the child is with a parent. Y'all have to fix that in family law court. Good luck.
Any other questions from these folks up here?
When both parents were previously custodial.
Yes, yes.
The other presenters are open to take questions?
Yes, they are.
We are?
Yes.
This is a darling one.
Yeah. They were clear. Anything else?
Yeah, I know. And it's gonna go towards what Jen felt. You know, when you distinguish the drug cases, first of all, I think ladle attorneys should be very, very proud, because I've done this work for a long time, and it is really ladle that took not just a local, not just a state, but a national drive to change the law in this area. And if you look at those drug cases, the majority of them are ladle cases. Every single one of those drug cases, an attorney came back to their supervisor and colleagues crying because they had this great facts and they fought it, and the judge said, no, your client's just smoking a lot of pot. Case after case after case, it was you guys that changed the law. Now, I think the distinction on the case where the mom was doing drugs in utero, that's our last.
Or the garage.
Or the garage. But that's sort of our last frontier. That's an area where the judges and the appellate court, it's sort of like, yeah, we get it if you're smoking marijuana. And then it's like, okay, yeah, we get it if you're doing methamphetamine. As long as you're a good parent, okay, fine. But, oh my God, if you do this while you're pregnant, you know, bring back Salem, Massachusetts and the witches. So it's an area where I have to tell you guys, if you scratch the surface, you're going to find out there's not a whole lot of hard science behind that. And we now have to develop those cases the way we develop the other cases. And I really do think that that's the one case that's out of sync, because it has to do with a woman who gave birth and it was a positive tox rate. So that's my challenge to all of you, is there's great law to be made. Talk to the experts, look at that, craft your defenses, because I expect in the next year or two, Ladle's going to make history again by really showing the state and the nation that a lot of those in utero drug babies are perfectly normal and very happy and were never put at risk.
Okay, thank you very much, everyone. Don't forget your
Let's get the code.